Are we ready? The Sprunger firm? Very good. Let's give a warm welcome of applause to the next speakers. Corey Sprunger, Natalie Williamson, and Brayton Conley.
Hello, like I said, my name is Corey Sprunger from Sprunger & Sprunger. We're from Indiana. So I've got myself and two other attorneys with me here. And I think they are on. I know we skipped forward, so hopefully they're on at the moment. So if they are, I will let them introduce themselves. Natalie, are you on?
Yeah, I'm here.
Okay, go ahead.
Hi, my name is Natalie Williamson. I'm an associate attorney at Sprunger & Sprunger. I previously was a teacher and taught my way through, I taught 7th grade English while attending law school. Upon completion of law school, I started as a full-time attorney with Sprunger & Sprunger, practicing family and criminal law. And parental alienation is also near to my heart, as I too was an alienated child growing up.
And our other attorney is Brayton Conley.
Good afternoon, everybody. Like Corey said, my name is Brayton Conley. I'm an attorney with Sprunger & Sprunger as well. I do family and criminal law. I'm a graduate of the Indiana University Robert H. McKinney School of Law in Indianapolis. After graduation, I spent 2 years in Toledo, Ohio, practicing labor and employment law. And then this past December, I moved back to Indiana, and I've been working with the Sprungers ever since.
Very good. So what we wanted to talk about is what I think is a really important issue, but it gets overlooked a lot. And that is the issue of how much it costs to litigate these cases. I think it's one of those things that we don't really want to talk about because it's sort of like that thing that we want to shove in the closet and forget about. But it's a reality and it's a problem. You know, these cases are hard, they're difficult, and you've got a lot of different disciplinaries coming together. You've got attorneys, therapists, GALs, I mean, you name it, there's different people going on, so it gets very expensive very fast, and I think it's important to make sure we talk about what that looks like. You know, yesterday, one of the presentations, I forget which one it was, but this topic slightly came up, and all of a sudden there was, 15 hands in the air asking questions about it. And I think sometimes there's a mentality that it's not fair. I shouldn't have to pay for this. The other side is doing this to me, and that is true, but it still has to be fought, and that's the issue. I put an analogy on here for those of you that are from the U.S., and obviously everybody knows their American history, but, Pearl Harbor wasn't fair either, right? Japan attacked us. That was not fair, but we had to fight back, and fighting back was not free. It cost something. Something had to happen. Right? We had to buy bullets, we had to buy planes, we had to buy tanks, we had to fight back. I think this is the same way, and I think the mentality really needs to start at the outset, understanding that and moving to the next step. Because a lot of times I think we want to say, all right, can we recover the fees? Before I jump into this case, can I get the fees back? And I really think that's the wrong mindset. The mindset needs to be, what's the goal here? The goal is to reunify with my children. That's the goal. And if it costs money, it's a fight. That's what it takes. So, if you can recover, I know in Indiana you can. Other states, I'm sure you can as well. But I just don't think that should be what you bank on. That's a bonus if it works. So, let's just kind of talk for a minute before we dive into some strategies. What are all the fees? Everybody in here is familiar with this, but let's just talk about them. You've got filing fees, attorney's fees, expert witness fees, evaluations brought in by other specialists. You may have, if it's a really intense case, a lot of times you got to go through appeals. You've got intensive reunification programs, which you just heard from Linda. You have post-program treatment after the fact. Every case is different, but we've seen cases that can run through, I'm going to call them quickly, for $20,000. That might be the low side. We've got some that go a couple $100,000. I've seen both. In our firm, I've seen both, all the way in between. And there's no case that's the same, right? And nobody likes to hear that, but we all know that's the case. So what's important is, how can we use that the best? Right? You have a limited amount of resources. Using the Pearl Harbor analogy, you have a limited number of bullets. How many are you going to use, and what are you going to use them on? Because it matters. So we got a couple of tips and tools for your tool chest here. The first one is what I'm going to call litigation mapping. This is deciding up front at the very beginning, what can we afford to do, right? So you don't necessarily need to have an exact dollar amount, but you need to have a concept of what we can afford to do. The more resources you have, the more battlefronts you can afford to open, right? You may only be able to have the resources to fight on one front, and if that's the case, pick the right front. Don't fight on a bunch of silly stuff, right? What I do in my case is I talk to the clients up front. I make sure they understand this is not a short-term thing. This is a long-term ordeal. And I start with for a family law case, what I would consider a higher retainer. I usually start with, about a $10,000 retainer. That just, at the outset, forces the question. The regular family law case, they're going to do a $2,000 retainer, right? It's just not a big deal. When you start off with an amount like that, that forces you to have the conversation to say, can we afford to do this litigation? Can we make it to the end? So up front, decide how many battles you can afford. Second is, based on that, decide your strategy, right? So I'm going to call this low resource, mid resource, and high resource, right? Low resource, I think of this like going hunting with one bullet. If you only have one bullet, don't start shooting off at all kind of things. Pick the right one. You got to shoot to kill. You get one shot. So I'll give you an example of one of my cases that I had. A client came in. It was clearly alienation. She had been alienated from her children for about 3 years. No contact. Dad had taken the kids, took off, was gone. Had no court order, no ability to do that, but had done it. She's, at this point, a single parent. She has one income, and it's a low income. So I said to her, I think this is alienation. I think you're right when you brought that issue to me, but we don't have the resources to go after a lot of things here. So here's what we're going to do. We're going to do a one-time flat fee, and we're not going to get distracted. We get one shot at this. So we're going to set it for court. We're going to set it for a 2-day trial, and we're not going to do anything else. So everything else that feels important to you, we're just not going to do it. So we're not going to chase down all the rabbit trails. We're going one time. We're going to get one witness. And actually, you just heard from Linda. She was our expert in that case. And she testified, and the judge went for it. This is an example where it worked. The judge ordered, found that there was alienation, ordered the alienating parent to pay for it, ordered the alienating parent to reimburse our parent for the entire $15,000 flat fee, put a 30-day sentence of contempt over him, suspended it unless he paid that, and said, in addition to the 90-day no contact order, in addition to going to the turning points for families, you also cannot have the kids back until you enroll in your own therapy. Dad never enrolled in therapy, and a year and a half, 2 years later now, the alienating parent hasn't seen the kids since. It's been a turnaround. The relationship was repaired immediately. I mean, it's amazing. But this is an example where if you're in a low resource situation, take your kill shot and go for it. You get one chance here, right? That doesn't mean it's always going to work, but you get one shot, take your best gamble, and shoot for it. If you're mid-resource, right, then you can fight a few more battles, and you know that up front. So you're saying, all right, there's a few other contempt motions we might be able to go after here and there. Maybe we can do some depositions before trial so that we're not shooting blind. You can sort of ratchet up a little bit and decide we have some extra options here. Some parents come in, they may come in, or they may have grandparents that come in, or someone that says, I do not care what it takes. So in those cases, you've got lots of bullets. Spray the field, go with whatever you need to. Do the depositions. Now there's a law of diminishing returns there, right? So you can overdo it, and I think it's incumbent on those of us that are in the room that are attorneys to be cognizant of that. Don't just do it to do it. You got to be a balancing act there, but it depends on what the client's wishing. And if they want to uncover every single stone, then have that conversation with them. But this is why I say it's important. I think step number one is determine what kind of resources we have to work with. And then step two is to build your strategy afterwards. If you just never do that, and you just charge in, and you were only low resource or mid resource, and you spent your bullets on some silly contempt motions, what was the point? There's nothing was accomplished. Which bleeds into step 3, stay focused, stay on course. So if resources are limited, don't chase the rabbit trails, right? So I can't tell you how many clients email and say, all right, mom just said this, can you believe that she said that? And I just heard of it from the kid, and file a contempt motion. I'm like, look, we've already filed 3 contempt motions. Judge hasn't granted any of them. He's not likely to grant this. Do it anyways. And I'm like, okay, it's a bad idea. We can do it, but we're wasting more money, and probably more important, we're wasting more time, because every time you set it for a hearing, it just pushes things out further. So here's a couple of resource-consuming traps that Natalie, Brayton, and I put together. One is motions for contempt, what I just mentioned. Be selective. Obviously, those are important. If you have a good judge, I forget her name, but the lady that presented yesterday who was up here, if you have a good judge like that who is on it, quickly makes the decisions, and is in charge of the courtroom, then these are good, right? But if you realize pretty quick, this judge is not going for this stuff, don't keep filing. It's not going to work. It's a waste of resources. Additional sanctions, extensions of time. So frequently you get questions, evaluators come in, we need a little bit more time. We haven't got it done yet. We need another 30 days. We need another 60 days. Are we going to fight those things or not? Because on the one hand, the more time that goes on, the worse alienation gets. But on the other hand, if you've got limited resources, is it worth scheduling a hearing to fight over whether or not you're going to grant a continuance? You're just spending your dollars at that point. Unimportant emails. This is an important one for, I think, clients and attorneys to be aware of. You get clients that email, 45 updates, in a 2-week period about all the different things that are going on. And you're like, thank you for that, but that's not helpful to your case. And you're spending your bullets right now, because I think sometimes people want attorneys to just kind of do their work for free, but that's all we have. Just like the therapist, just like pretty much all the professionals in this room, we don't sell widgets. We have our time and our knowledge. That's all we have. So it's fair for attorneys to charge for their time. That's what we do. And you're using a lot of it with a lot of emails. You're using up your resources. And again, if you're a high resource situation and you're not worried about it, fine. But if you're in the low or the mid tier and you decided that at the front, don't be doing that. That's going to cause a lot of time. And it's on the attorneys at that point to come back and say, hey, consolidate your questions, send me one email with 15 bullet points instead of 15 emails, Tool number 4, maximizing use of the court calendar. One thing I've come to realize, I guess you could say, is the biggest enemy in litigating an alienation case is time. I have one case going on right now that has been going on for 7 years. They came to me with no contact for 2 years, and we're 7 years later, and there's still no contact. And why? What is happening? And it's just purely litigation. We reach an agreement. The other side doesn't follow through. So then you spend 3 months arguing over why aren't you doing your side of it. Then you file a contempt. Then it takes 2 months to get the contempt hearing scheduled. Then you have the hearing, and then they say, well, okay, next time do it better. So then you go again. And then you set it for court another time. Then they ask for a continuance. Then you ask for another hearing. It's the litigation itself takes too long. So here's a couple of tips, just a couple of ideas. The first one is, when you're scheduling your hearings, how long do you schedule it for? When I first started getting into these, I worked with another attorney, and he wanted, he was talking about maybe a week-long hearing. And I said, man, if you do that, there's no way we're going to get a week on the court's calendar for probably a year. That's just not going to happen. But the flip side is we had another one where we set it for 1 day and we needed 2 days. So you only get halfway through, and now you got to come back another. So you got a balancing act there, but it's incredibly important to decide how many days do I want. I would venture to say most family law courts are used to a half a day or maybe a day as max. And if you're asking for more than that, they're going to be looking at you a little bit strange. You're kind of getting off on a bad foot. But these cases take more time to explain than a normal family law case. So I feel like 2 days is sort of the sweet spot. You might need a half a day for miscellaneous motions that are put together, another half a day for some kind of an expert to explain to the court what is parental alienation. What does it look like? What are the manifestations? What are the behaviors? What are we looking for? You need that. And then a little bit of time to flesh out the facts. So if you can get it in 1 day, you're going to get a hearing in a lot faster. But if you need 2 days, it's just, my point is the more days you add, the further out the calendar is going to get, and it's important to be cognizant of that. Another one is utilizing status hearings. I've got 2 cases right now going on that I can think of where this has been invaluable. One of them, at our very first hearing, I did a pro hoc vice. I'm from Indiana, but I did one in Tennessee. And at the very outset, I told Judge, kind of a heartfelt plea. I said, Judge, look, if you don't do something, this is never going to get fixed. But this really honestly is on you. And if you can't step up and help us fix this situation, it never will, because these parties are incapable of fixing it. And the judge took that seriously, and he said, okay, you know what, here's what we're going to do. We're going to have status hearings every month on the first Tuesday of each month. And it's going to be quick. It's going to be 5 minutes, but I want to know what's going on. Are we getting somewhere or are we not? And that was helpful because the case didn't just die. It didn't fall into limbo land. It was being on top of. Another case where we utilized these status hearings, judge understood that we had like 50 pages of the chronological case summary. I mean, it's just like this litigation just kept going. And he understood that setting it for regular hearings, doing subpoenas, doing all this stuff was just taking too long. So every time a motion would get filed, he would just set it quick for a status hearing. And it was an attorney-only status hearing. And he heard the arguments, figured out what was going on, and gave us some guidance. Now, he's not going to give you a full-fledged order from a status hearing, but he's giving you guidance, right? So right at the outset, he says, he tips his hand, says to the other side, why is your person not bringing the child to therapy? And they give this big fluff argument. He says, that's bullcrap. Get your kid there, or we're going to have a hearing, and I'm going to hold him in contempt, right? And so there's those little kind of touch points where we kept it moving, kept the case going, as opposed to waiting for months for a full-fledged hearing. I think it was important to note that attorney-only status hearings can be really productive. I know those of you that are parents in the room probably don't like to hear that because you want to be there and you want to know what's going on. But the truth is more gets done because both of the attorneys don't have any theater they have to do, right? So we had one of these status hearings where one of the parents showed up, and the judge wasn't too happy about it, but he let him be there since they were there. And the tone was completely different. Both attorneys felt the need to prove themselves to their client. So now they're arguing and being much more flamboyant. And when we were just together with just the attorneys and just the judge, we were getting somewhere. Judge was, what's the problem? Why are we stuck here? We could get places without having to, show yourself to the client. So that's helpful. Another big one is scheduling dates before you need them. So, for example, if you've got, another case I'm thinking of right now, we scheduled, we did like a trial phase where we said, we're going to try this for X amount of time with therapy and all this. But we don't think we need a hearing, but we're going to go ahead and schedule a hearing right now for the end of that 6-month period. Because I guarantee you something is going to come up. And I would rather have a date now than get to the end of the 6 month and then need to schedule a date, and it pushes it out even further, right? So being proactive and getting those hearing dates now instead of waiting until you need them has been invaluable. And this leads right into tool 5, which is time is your enemy. So again, setting those dates in advance, stressing to the court that time is of the essence, making sure that these judges remember that there is usually no parenting time happening on one side. And every day that goes by, it gets that much harder to fix. And so really stressing that, and when the judge says, all right, let's set this for a hearing in 3 months, and we'll come back and see how things are going. You say, well, time out, Judge. Can we get any faster? Because this is important and we're losing time. Ancillary motions, getting them into one hearing. So you got, usually 10 different things going on, 3 contempt hearings, this, that, and the other. Get them all together, right? If resources is important, get them into one hearing. That saves everybody the drive time, saves everybody the preparation time, save a lot of resources when you can consolidate those things together. And the last one here is agreements are like gems. They're beautiful, but they're rare to find. So it's a double-edged sword, right? Because on the one hand, you can waste 3 months going down the trail of trying to negotiate an agreement only for it to come to nothing. Or worse, you reach a bad agreement with no enforceability or no specifics. But if you can get the right kind of an agreement, it can short-circuit the whole process and get you moved on. So if you can get one that has specificity, you can get one that has enforcement mechanisms, and you can get one that gets straight to the root of the issue, do it. Which I guess hit all those on that one there. So in summary, I know we're short on time here, and I anticipate there's probably some questions on this one. I would say, number one, accept that it's not fair. It isn't. If you can accept that and move past it, focus your energy on winning, not on recovery, right? Number two, the more resources you have, the more bullets you have, right? The more bullets, the less of a kill shot you have to go for. But it's important to define that at the front and decide for yourself what you have to work with. And then finally, deploy that strategy accordingly. So stay focused, don't get sucked into ancillary rabbit trails, make good use of the court calendar, recognize that time is your enemy. The longer this drags on, the worse it is, and make effective use of agreements, but don't fall into the trap of bad agreements. That's kind of my summary here. So I think we have like 3 or so minutes or so. Okay, so do you guys have any questions?
We need a microphone for the questions for people that are on Zoom.
Yep.
In utilizing or requesting status hearings, how are you then able to get facts, the underlying facts to the court in giving an update and making whatever the request, substantiating, justifying your request?
Yeah. What I found is that these judges, usually by the time I get involved, it wasn't identified as a potential alienation case at the outset. And so, you've got, I don't know what it's called in other states, but we call it their chronological case summary, CCS. That's the list of all the entries of everything that's happened in the case. And in these, normally you might have a 2 or 3 page CCS. In these cases, it's always 50, 60 pages. And by that point, the judges are just plain frustrated. And so when you get to that point and you say, can we just get a status on this? A lot of times you can get a half-hour remote, a video or a phone call status, and you can just say, Judge, we didn't want to have more litigation. So here's the issue. This happened, this happened, this happened. What do you want us to do? You want me to, how do you want to handle this? And at that point, they're usually frustrated enough that it's like, just give me the info and let's get through this and figure out what's going on.
I'm told I have the last question over here by Virginia. Question for you. In your jurisdiction, are there any reported cases where a cutoff order or change of primary was sustained as the sufficient basis, based upon parental alienation, was sustained as sufficient basis? And the corollary to that is, have you had in your jurisdiction parental alienation sustain a Daubert challenge? Thank you.
Well, I think your question is asking about has one been found and then appealed and sustained. Is that what you're asking? Yeah. I don't believe we've had any in Indiana that specifically call it out, but we've had trial courts call them out and say what it is. We have not had any say, no, this is not an acceptable thing. I've even had some cases, I had a case personally where they found that there was not alienation. That was appealed, but even though they said there wasn't alienation here, they said in the trial court that we still find that parental alienation is a real thing. We just don't think it's happening in this case. That case was appealed, and of course, there was no judiciable issue in front of the court to ask on, but of course they didn't have any dicta or anything else on that either. So there's nothing disfavorable, I guess, is kind of where we're at.
All right, let's give a round of applause to Corey. Thank you so much.